We've seen that the AI Act will apply to AI systems. The second element that defines the scope of the AI Act is geographical. The AI Act is a regulation of the European Union. This means that the scope must be limited to the European Union, which of course cannot legislate laws on behalf of countries outside of the EU. So, for the AI Act to apply to an AI system, that system must have a connection with the EU. This means that the AI Act applies to AI systems developed or used by entities established in the EU, put into service, placed or made available on the market in the European Union, that produce an output used in the EU and that affect people in the EU. The AI Act will apply to an AI system where any one of these 4 criteria apply, which means it has what is called extraterritorial effect. This means that the AI Act applies to companies located outside of the EU, where those companies are sufficiently connected with the EU. This means that the AI Act is relevant even to companies based in, for example, the United States, China, Brazil or Australia. The European Union is an extremely large and potentially profitable market for many large enterprises, and any company that wants to use AI in the EU will need to comply with the AI Act. Many laws enacted in recent years in the EU and around the rest of the world operate in this manner, since technology products are increasingly reaching beyond national borders. An obvious example is privacy laws, with the GDPR having an extraterritorial effect. The result is that multinational corporations often need to navigate and adhere to a wide range of diverse and sometimes conflicting legal regimes. Whilst it's a grey area that's not properly settled, configuring a website in a certain language, for example Italian, may be enough to give the appearance that the AI product is intended to reach that country. For example, a website configured in the Italian language may appear to be targeting Italy. Some of the criteria that define the geographical scope of the AI Act contain within them terms that can be further defined. For example, the second criterion relates putting into service, placing or making available on the market in the European Union. Placing on the market means the first making available of an AI system or general purpose AI model on the Union market. Making available on the market means any supply of an AI system or a general purpose AI model for distribution or use on the European Union market in the course of a commercial activity, whether in return for payment or free of charge. We've seen from other areas of law that the exact criteria that constitute whether a product is made available on the EU market will depend on the exact factual circumstances. Factors such as languages available, currencies for payment, the use or not of geo-blockers, and whether the product could be deployed or shipped to the country are all relevant considerations. Businesses will need to take care to properly evaluate such considerations before determining that their product has not been made available on the EU market. These definitions will be useful again later on in the course, once we start discussing the substantive obligations on certain AI systems. For example, they present a moment in time for compliance with obligations, in that certain obligations must be fulfilled prior to the AI system being placed on or being made available on the EU market. That's all for today. Looking forward to seeing you in the next video.